Good evening, those of you who are able to join us for our third lesson towards the 2023 Law School Entrance Examination revision. Now, we have stated that every day we do a different subject so that by 6 days, we have done something in each of the 6 examinable subjects. Yesterday, we discussed constitutional law. Tonight, we are doing contracts. And the approach we are using is that we are not leaving any stone unturned, because I advised in my very first lesson that it is not wise to just concentrate on just 1 or 2 questions, but it is better to assure yourself that you have a reasonable understanding of all topics within the 6 subjects before you can devote a lot of energies towards maybe questions in the various topics areas. Because after all, if you don't have graphs of foundations, then what is the point? So on that note, contract, just as we did for constitutional law, we are starting from the very scratch, but we'll go very fast. And those of you who have also followed this online teaching I do, we also have a lot of previous recordings, the same topics which are being taught every now and again. So in addition to this, some of the previous recordings too, if you have them, the same thing, good. So tonight we want to first concentrate on the test of agreements. How can we say that agreement exists? So before that, I want us to go back to certain basics. We move very fast. First of all, we know that law of contract is a private law, or it is an example of a typical common law subject. And it is that area of the law which deals with the relationship which parties are brought between themselves by their free negotiation. So the bottom line of contract is consent. Everything contractual, it comes back to consent. Who parties or the 2 sides, have they freely given their consent? So that is what we should have at the back of our mind. Then again, we have to remember that we have 2 main types of contracts. We have what we call like the simple contracts, and then the specialty contract. Specialty contract, also known as contract under seal or by deed, is a contract which has been reduced into writing and some other formalities, including the seal of the parties. The seal will signify the fact that the particular person whose seal is being used has actually consented. And that is why in your LLB days, you were told that as far as specialty contract is concerned, there is no requirement for consideration because of the presence of the seal. Because the seal is your official sign of approval, of imprimatur, so that you keep it securely. Because if someone gets it and put it on a document, the document will be given all the respect which should be given. So that is a specialty contract, also known as a contract under deed or contract by under seal. Then we have simple contracts, and which I would say constitute majority of contractual transactions or scenarios that we have. Simple contract, a contract which is not required to be in writing. Let's understand, we are not saying that simple contract cannot be in writing, but the emphasis is that it is not mandatory that it should be in writing. So you could have it in writing, and it will fall short of the other formalities of specialty contract. It will not have seal and so on, because if you have that, then it's no longer a simple contract. It is a specialty contract. But quite often, a simple contract, also known as a parole contract, will be by word of mouth. And that is where we direct a lot of efforts, especially at the formation stage of contract. How can we be sure that the parties have actually agreed upon no particular thing? Especially so, they've not appended their signature to anything. They have not put their seal on anything. So how do we establish that? Yeah, so that is what we want to spend a bit of time on. The test of agreement. We'll later come and learn about the constituent aspects, the various elements, offer and acceptance, intention, consideration, and so on and so forth. But so therefore, we are told that the test of agreement is objective test. Objective test. And I want us to understand that well. When we say that the test of agreement is objective, or we use the objective test in order to find out whether in the simple contract or parole contract situation, the parties have actually reached an agreement. What does that entail? How do we go about it? Well, let us remember that when the two parties were negotiating, it may well be that they never even met physically, either by phone or by some other remote negotiation and so on. Agreement can still come into existence. There will be dispute, and one will say that we never agreed on this or we never agreed on that. So how will the court go about trying to establish what the parties actually agreed upon? So this is where the objective tests become important. And by the objective test, we are saying that the court will try and find out using the somebody has put something in the chat. Let me see. It's in the chat. Oh, you cannot hear, sorry. Okay, so follow what Augustine has put in the chat, I'm sure to help. So by the objective test, the court will try and find out the position or the perspective, the point of view of an imaginary person known as like the reasonable person, or what in contrast again you call the officious bystander. So the court will assume that at the time that the parties negotiated, however they dealt, whether physically or remotely and so on, assuming you had a reasonable, disinterested party, someone who is not one of the parties, just a bystander. He doesn't have a bias towards any of the parties. He's very neutral. So listening to whatever the parties told each other, or looking at whatever correspondences, right? Whatever letters which the parties exchange and so on. What would a reasonable person have understood the two parties as having really agreed upon? So what the disinterested, the officious bystander, or if you like, the reasonable person would have understood the parties as having agreed upon is what will be taken as agreement, and not the subjective intentions, not what each of the parties were individually thinking in his or her mind. And we all know from our LLB days, the case of Smith and Hughes, and then the Tamplin and James, Scriven brothers and all that. Remember the case of the Smith and Hughes about the sale of the oats, where one person was thinking of selling an old oats, and another person was thinking of buying a new oats, and there was confusion as to what was the subject matter of the agreement. Of course, in Smith and Hughes, the court ordered retrial, but then the court pronounced upon what has become known as the objective test, that it is what the reasonable person, the official bystander, who does not have any particular bias, he looking at or he listening to what the parties did, what he understood to be what they were actually doing is what will be taken as the agreement. And that is why Justice Blackburn, Lord Blackburn, he made the famous dictum, which is often quoted when we are discussing objective tests. And Lord Blackburn in Smith and Hughes will say, and I quote, "If whatever a man's real intention may be, he so conduct himself that a reasonable man will believe that he was assenting to the terms proposed by the other party, and that other party, upon that belief, enters into the contract with him, the man thus conducting himself will be equally bound as if he had intended to agree to the other party's terms," unquote. In other words, Lord Blackburn is telling us in Smith and Hughes that if by your words, by your action, you create a certain impression, and even if you had a reasonable person observing whatever you have said and whatever you've done, if you have understood you to have actually meant a certain state of affairs, and then the other party also relied or believed what you had actually created, that will be taken as well as an agreement. It does not matter that you meant something different. And that is why in the case of Tamplin and James, as you remember very well about the auction sale, the sale of a property, a person who went to the place where the auction was taking place, he was very familiar with a particular property which was being offered for sale. And because of his sufficient familiarity with it, knowing the gardens and all that, when he went to the auction room, he was given a brochure which contains information about the exact specifications of the property being offered for sale through the auction. But he never bothered to read through the brochure. And eventually, the auctioneer knocked down the hammer. And when it was time for him to make payment for that which he had purchased, the reality dawned on him that what he had actually purchased was did not include certain other things, certain garden, which he thought was part of what was being offered for sale. And he insisted that, well, if you are not going to add that, then I will not pay. Then the matter had to go to court. Then the matter came to court, and the court will say that, let's look at the scenario. A property is being offered for sale. Information about the property is contained in the brochure, which is there. So any reasonable person there will actually understand that what is being offered for sale is what has been described in the brochure or the documents in the auction place. that is what is being put up for sale, and not what the prospective purchaser was thinking in his subjective mind. So it does not matter that in his subjective mind, he thought that something else was being offered for sale. So that is what the court was reminding us. Tamplin and James. So if we have understood that the test of the agreement is objective and not subjective, then we move on to quickly revise some other things so that within the limited period that we have, we'll be able to cover some significant grounds. Good. Now let's come back to our very famous area, which a lot of students are comfortable with, and we may even take it for granted that it will not be examined. So why do we have to worry ourselves about what they call a very elementary thing? That is the offer and what? Acceptance. So offer and acceptance. So first and foremost, an agreement, right? An agreement is signified by the coincidence of offer and acceptance. So that is the first point we should keep in mind. Particularly so when we're dealing with simple contract. Because mind you, as we have said, simple contract, it has not necessarily been reduced into writing with the signature of the parties and so on and so forth. So how do you establish the agreement? You establish the agreement by finding out whether there was an offer and whether this offer had been accepted. If you can see offer and acceptance, then you have an agreement. But mind you, we don't have to rush. The fact that you have an agreement does not mean that you have an enforceable contract. An agreement is not equal to enforceable contract because there are some other things which will need to be present before the agreement that you have can be enforced in a court of law. So being a simple contract, there's a need for consideration to be provided. We'll discuss that later on. Of course, all the time, it is important that people who are making agreements must be qualified in law. They must have capacity. If you are not qualified in law to enter into agreement, despite the fact that we can establish offer on your part and acceptance on the part of the other party, we cannot say that there is enforceable contract. So let's keep that in mind. And that is why sometimes it will be said that every contract is agreement, but it's not every contract, which is, it's not every agreement which is contract. It's really relates to the point I made, the enforceability, right? Because you can have an agreement if there are some other fact, like you have illegality. Maybe the agreement is contrary to law or public policy, then that will not be enforceable. Or consideration has not been provided and so on, then that will not be enforceable, being a simple contract, as it were. So let's keep that in mind. So let's come back and take the offer and quickly revise that. We know that offer simply refers to expression of willingness on the part of one party, called the offeror or the promisor, to be bound on stated terms if those terms will be accepted by the other party to whom they have been intended or they have been addressed. So that is an offer. So offer is simply the fact that you have expressed an intention that you are ready to be committed on certain terms, right, which you have indicated, if they'll be accepted by the other party. And that is why the authorities will tell us that there is an element of finality, right, in an offer. Offer presupposes that negotiations and everything, you've gone past that. So you have element of finality on your part. You're not going to enter into negotiation with the other party again. And that is why later on, when we are discussing acceptance, there's something called a counteroffer. Because the offer is a final or a definite proposal by the offeror or the promisor to be bound. So he's just waiting for a nod approval. No room for tweaking it or modifying it or anything, no. So let's keep that in mind. And that is why we will say that there is something which looks like an offer, but it's not an offer, what we call the invitation was to treat. And the most important distinction between an offer and invitation to treat is that in the case of invitation to treat, you are just calling upon the invitee, right, whoever you are inviting, that he should let us negotiate. He should let us talk. Let us discuss. You are not saying that you have a definite terms, you are prepared to be committed. No, you're only showing that you are available for talk, you're available for negotiation, and so on. So there's no commitment on your part. If the negotiations and all that progress, an offer will come out of that. So a successful invitation to treat will result in an offer, which may be accepted or rejected. But in the case of offers, we have said, it is a definite promise, or it is a definite expression of intention or willingness to be bound. So it is either accepted or rejected. So let us keep that in mind. And of course, the plethora of cases which we cannot exhaust, and you know them, the case of Gibson against the Manchester City Council. And then the well-known case of the NTAC versus the entry. As I indicated in the first lesson, we have so many authorities on just a single principle. So therefore, you can do the barest minimum by knowing at least 2 authorities. The reason why I would say 2 is that if you forget one, you'll be able to remember the other one. So that is a very safe way to strategize. But if you learn only one, and then the other one that you have learned, you forget it. What it means is that you don't have any authority, and you'll be writing your answer without authority. And as I indicated, as far as contract is concerned, we come and talk about tort when we are doing tort. Now we are learning contract. As far as contract is concerned, in any examination, any law examination, and more so in the law entrance examination, if there is a question and you write, especially a scenario or problem-based question, and you write your response without any authority, you will definitely not get a pass mark for that, because you mark so low. So much so that unless you have really, if you like, written something extraordinary, impressive, otherwise you will not cross the pass mark for that particular question. So let us make effort, and you get the principles. So for example, now let's assume you are learning contract on your own. You take the very introduction. So offer, what are the essential principles? as far as offer is concerned. So the meaning of what? Of offer. And then the distinction between offer and invitation to treat. And for each point, you have to get at least a case. So as I indicated, the most important distinction between offer and invitation to treat is the finality. And there are a number of scenarios where the court have said that something which looks like an offer is not really an offer, but it's an invitation to treat. And you know them. We all know the situation of advertisement. When it comes to advertisement, the position of the law should be stated in two ways. We have advertisement in the nature of potentially bilateral contracts, and then advertisements in the nature of potential unilateral contracts. Now, that distinction is important because you cannot just jump to the conclusion that every advertisement is an invitation to treat. Then it is not an offer. That would be a mistake, because you can have advertisements which is going to be a unilateral contract. For example, advertisement that anybody who will bring information leading to arrest of a particular criminal will be given a certain reward. It's an advertisement, all right, but that advertisement is unilateral contract because it does not require any specific acceptance by whoever is interested in responding. The acceptance required will be you performing the required act, that is bring information which will lead to the arrest of the person. Once you have done that, you have accepted it. So here, you see the advertisement is actually an offer because it satisfies the element of what finality that you talk about. And you remember the well-known case of a Carly against Carbolic smoke ball case. You remember that, and so many other cases like the case of Williams and Kawadan, Fitch and Senedeka. All these were advertising cases, and they actually brought about unilateral contracts. So that was not treated as invitation to treat. On the other hand, where the wording of the advertisement suggests that it is actually expecting people to respond and to come forward and make an offer, which may be accepted or rejected, then we can say that that is invitation to treat. Just like the old case of Partridge and Crittenden. I remember the sale of the Blambenfitch hens, Blambenfitch cock with the stated price. And the court reasoned that such an advertisement certainly was an invitation to treat. So that if you responded, you will make an offer, or an offer will be made to you and then to be accepted or rejected. So let us keep that in mind. And not only that, what about auction? Where there's an auction, you know the situation about auction, that the announcement that there's going to be an auction does not create any binding obligation on the part of the auctioneer or whoever caused the announcement to be made. And you remember those old English cases, Harris and Dickerson, Wallow and Dickerson, and so on, where the court will make the point that there's a policy rationale that if all the people who are going to respond to the advertisement, and for that matter, will travel to wherever the auction is going to take place, were owed a duty, then the auctioneer was going to be overwhelmed by multiplicity of claims. So because of the floodgate argument, the court will say that such announcement does not give rise to an offer by just an invitation to treat. And also the auction itself, we go to a place where an auction is being made, and the auctioneer invite bids. The bids per se, I mean the invitation for the bids, right? You are going to make the offer by giving quotation. If the auctioneer is satisfied with the bid that you are making, then you indicate the acceptance by knocking down the hammer. And you remember the PNDC law on the auctions law, what the auctioneer can do and what the auctioneer cannot do as far as the reserve price is concerned. Good. Then we also have the tender as far as the tender notice is concerned, and tender to as whether it is an offer or invitation to trade would depend very much on how it is worded. But where there is just notice that there's going to be a tender, or that we are soliciting tender bids, people to make an estimate for supply of certain things and so on, that one is not an offer. So you, the person who respond to the requests, you are going to make a proposal, you are going to make an offer, which may be accepted or rejected, particularly when it comes to procurement areas. So let us keep that in mind. Of course, we also have standing, offer situation, especially in Ghana. We have what we call, if you look at the procurement practices, we have the pre-qualified suppliers and providers. So as part of the procurement planning, also in accordance with the law, various companies and organizations will try and invite potential suppliers and service providers to come and register with them and so on, so that they will pre-qualify. And if they are going to do any procurement within the particular period, those who have been pre-qualified are the ones that will be sent, if you like, tender circulars or notices, and then they can actually put in a bid or a proposal. What about display of goods, where goods are displayed in a shop? And I would like you to pay attention to this. If you get an examiner who wants to just play around with students on very simple matters, you can set a scenario question, right? Using display of goods in a shop. Now supermarkets or malls are gradually springing up in Ghana. And let's create a scenario which will also involve, maybe you cause a damage or something like that, like the Lasky against the grocery economy, that US case. And let's suppose that there was some kind of heated exchange between you and the tenant, or some kind of altercation and all that. And they have come to you to advise them regarding what the legal options are. Have they got a course of action? No. So that scenario, for example, it looks simple, but that is a very interesting area to be tested. So you will have to fall upon your appreciation of very elementary knowledge in contracts to start with. And remember that when goods are displayed in a shop or any place where they are selling things, the mere display of the goods with even a price tag on it per se is not an offer, but an invitation to treat. And at least following the English jurisprudence or case law. That is the position. As you know, Fisher and Bell, Pharmaceutical Society of Great Britain against Boots and all that. That is the position of the law, that it is a mere invitation to treat. So the person who is going to pick the item will go to the retail or the sale point. It will be there that he presented to them. So it's an offer that you are making. I offer to buy this item at the price indicated on it. Then they can accept it and let you buy it, or they can say no. If you took it to the counter and then they said no, you could only be angry. You sympathize with your anger, but beyond the anger, you don't have any legal claim against the shop, as it were. So let us keep that in mind. Okay, so it's 9:49. Let's do a few more minutes before I will release you to ask questions, and then we draw the curtain down. Okay, now let's time. Okay, it's 9:50. No, let you ask questions so that we can finish. I have to do some other things. Okay, so if you want to ask question, please raise up your hand and then you'll be allowed to speak. And let the question be focused on the subject that we are learning in the topic area, right? Otherwise, we'll be all over the place and then we lose focus. If you raise up your hand, you'll be released. Let's say you'll be learning and there's something bothering you. This is the time for you to discuss it so that we can all learn from it. Anybody? Okay, so you're all masters in contracts. So I'm confident that any question around this area, at least what we've done today, you'll be getting the full marks. That is good. Okay, so what we do is that I will try and get a question which fits within what we have done, especially so if there has been a past question from the previous entrance examination relevant to what we have done, then we can bring it up and we look at it as part of as part of the revision that we are doing. But as I also said that if you have any particular thing you would like us to discuss in the various subjects areas as we move along, that is why we have like the platforms there. Just indicate on the platform or you send it to me directly so that we will include it and give it attention when we meet together. Okay, so have a good night then. Somebody said we should share something. Okay, so there's a question. Can there be, I think someone has a question. Can there be a price variation once there is a price tag on the good displayed? Okay, that's good. So you go to shop and then you tell the shop attendant that in your law of contract class, you are told the law is that the goods displayed is just invitation to trade. So you are not ready to pay the price indicated. You want to quote your own price. Well, you'll be very much welcome to do that, but whether they will let you take the item out of the shop, I doubt. You go without the item. Yeah, so what we have learned is the, if you like, the orthodox position or the theory, right? Not even like that. I mean, that is what it is. It's not the case that you are going to quote your price, because you go to some shops. Let's go, if you go to Kantamanto or you go to KJTia or you go to some of these Cape Coast or Takoradi markets, the items are there. You have to even suggest a price. So the mere fact that there's a price tag does not change the position of the law, that it will make it an offer. And don't forget, English law, the common law is actually based upon a lot of common sense. And part of the common sense here has to do with the policy, public policy consideration. Just imagine if the law were to be the other way around, that the display of the items is actually an offer. You can imagine how people will be filing suits against shops. You go there, and then you may even, you take the item there. For all you know, that item is even just for display. It's not even for sale. You go to the shop, sometimes they have items which are just for display, just to let customers know that we have these new items and so on. You pick it, and assuming the law were to be the other way around, that it is an offer. If they don't let you buy it, you may probably have some other complaint. But of course, if you analyze it theoretically, one would also say that even if it is an offer, the fact that you have an offer doesn't mean that it should be accepted. An offer can be rejected. And that is why in the US, if you look at the case of Lasky against the grocery economy, with Sheshe and Fyford, those of who use it will actually cite it, in contradistinction to the case of Pharmaceutical Society of Great Britain against Boots. And what happened there? And then over there, a woman was in the shop, a glass, an item got broken, then she got injured. Then there was a suit, and the question was whether an offer had been made or just an invitation to treat. And there, the court took the position, I mean, this was under US law, the court took the position that the display was an offer, but then the contract will take place at the sale point where you will present it, and then you make, they will have to accept it. You will have to accept it or reject, because they have made an offer to you. So when you take it there, it's like you're accepting it. But if you look at it closely, then the end results are practically the same. The end results are practically the same as what the English approach in the Fisher and Bell type of cases seeks to achieve. Yeah, so that is, or anybody has got like other thoughts regarding set or sense question? Okay. Have a good night.